if law enforcement ever shows up at your door because a neighbor, relative, or even your partner requested a wellness check. You need to know precisely what the Supreme Court has ruled they may and may not do with your firearms once they're standing outside, because the reality is far more nuanced than either camp in the gun debate prefers to acknowledge. Some time back, the Supreme Court handed down a unanimous 9-0 opinion, rejecting the notion that officers can enter your residence and confiscate your legally owned weapons without a warrant, simply because they've concluded you could pose a threat to yourself or another person. All 9 justices concurred on that fundamental principle. Yet here's what almost no one explains with clarity, and it's precisely why this identical legal issue keeps reappearing in courtrooms nationwide years afterward, with the Supreme Court consistently refusing to return and resolve the questions it intentionally left hanging. I'm going to guide you through what that original ruling actually held, what it purposefully avoided deciding, why lower courts have continued battling over the gap ever since, and why the justices' ongoing reluctance to revisit the matter carries weight equal to the original judgment itself. Before diving into the details, if you want to grasp your actual rights the instant a legal gray zone like this gets tested again, hit subscribe and enable alerts, because I monitor these collisions between the Second Amendment and Fourth Amendment the moment lower courts hand down decisions, not months after the narrative has been reduced to a soundbite. Let's examine precisely what the court held and why it remains significant. The case driving this entire discussion is Canelia versus Strom, decided by the Supreme Court in May 2021. The underlying facts matter because they reveal exactly why this case became the benchmark everyone references. A man in Cranston, Rhode Island, had a heated dispute with his wife. During the quarrel, he set an unloaded pistol on the kitchen table and said something along the lines of, "Why don't you just put me out of my misery?" His wife departed and stayed at a hotel overnight. The following morning, unable to contact him by phone, she contacted police and requested a wellness check. Officers arrived, located the man on his porch, and concluding he might pose a danger to himself, arranged transport to a hospital for a psychiatric evaluation. According to the man's subsequent account, officers assured him they would not take his firearms while he was away. Once he departed for the hospital, officers entered his home anyway and confiscated 2 handguns. He filed suit, contending the warrantless search and seizure breached his Fourth Amendment protections. The lower tribunal, the First Circuit Court of Appeals, sided with law enforcement, ruling that a legal doctrine known as the community-caretaking exception, originally crafted for police searches of automobiles, also applied to residential searches when officers believed they were safeguarding someone rather than probing a crime. The second portion covers what the Supreme Court actually held when the case reached them. And precision matters here, because the exact language of a unanimous opinion like this carries massive influence in every future case that relies on it. Justice Clarence Thomas authored the opinion for a unanimous bench. The holding was tightly focused but unequivocal. The community caretaking exception, first acknowledged in a 1973 decision called Cady versus Dombrowski, concerning a search of an impounded vehicle, does not stretch to searches and seizures within a person's dwelling. Thomas wrote that the very essence of the Fourth Amendment safeguards an individual's right to withdraw into their own residence and be shielded from unreasonable government intrusion, and that what is reasonable for a car stranded on a roadside is fundamentally distinct from what is reasonable for a private home. The court squarely rejected the idea that police possess some broad, open-ended authorization to enter residences and remove property whenever they believe they're fulfilling a caretaking role rather than conducting a criminal probe. If you're seeking the headline takeaway in a single sentence, here it is. Law enforcement cannot rely on good intentions alone as a replacement for a warrant when your home is involved. The third portion is the aspect of this ruling that nearly every video and article covering it at the time either ignored entirely or badly oversimplified, and it is the single most critical detail for understanding why this legal conflict never truly concluded. The Canelia opinion was notably brief, only a handful of pages, and the court deliberately specified what it was not resolving. The opinion explicitly refused to address whether other established exceptions to the warrant mandate, such as exigent circumstances, meaning an emergency where someone's safety faces immediate jeopardy, might still justify a comparable search under different circumstances. Justice Samuel Alito authored a separate concurrence specifically to highlight that the ruling said nothing whatsoever about the constitutionality of red flag laws, the state statutes permitting courts to order temporary confiscation of firearms from someone a judge determines poses a danger to themselves or others. Alito stated plainly that this case does not present a request to develop a body of law concerning those red flag statutes, and the court's ruling should not be interpreted as prejudging that issue in either direction. Justice Brett Kavanaugh wrote his own concurrence stressing that police still maintain the capacity to assist in authentic emergencies through other established doctrines. So the true scope of Canelia is narrower than the triumphant headlines from 2021 implied. It eliminated one particular legal theory. The community caretaking exception applied wholesale to residences. It did not settle the far larger and more frequently litigated question of what occurs when a formal judge-approved emergency risk protection order is involved, which is precisely the type of order employed daily under the approximately 20 state red flag statutes currently in force. Here is a concrete illustration demonstrating exactly why that distinction carries practical weight. Picture two virtually identical scenarios unfolding the same evening in two separate states. In the first, police respond to a wellness check, make an independent judgment that the resident's weapons should be removed for safety, and confiscate them without ever approaching a judge. Under Canelia, that seizure is unconstitutional, period, regardless of how noble the officer's motives were. In the second scenario, a family member petitions a court that same evening. A judge reviews the petition and signs a temporary extreme risk protection order, authorizing confiscation of weapons pending a full hearing, and officers execute that judge-signed directive. That second scenario appears virtually identical from the outside. Firearms leaving a home the same night based on a safety concern, yet it rests on entirely different constitutional ground, because a judicial officer, not a police officer acting unilaterally, made the determination. That lone procedural distinction, whether a judge approved before or after the weapons left the house, is the entire game in how courts have treated these situations since 2021. And it is precisely the kind of technical nuance that vanishes when this story gets compressed into a headline. The fourth portion covers what transpired in the years following Canelia, because this is where the narrative most people never hear actually plays out. With the narrow scope of the ruling now clarified, lower tribunals across the nation have spent years processing cases, testing exactly where the boundary lies. Does Canelia mean police require a warrant before removing weapons even in a genuine rapidly unfolding emergency where someone is expressing active suicidal intent in real time? Most courts have answered no. That genuine exigent circumstances, meaning an immediate life-threatening situation, remain a distinct and still valid basis for warrantless action, precisely because the Supreme Court explicitly stated it wasn't resolving that question. Does it mean state red flag statutes, which require a judge's signature before weapons can be temporarily removed, are constitutionally sound? Multiple state courts have upheld ERPO laws after analyzing them under the historical framework the Supreme Court later established in a separate 2022 decision, concluding that because these laws generally require judicial authorization rather than an officer's unilateral decision, they don't encounter the identical problem Canelia identified. But the litigation is genuinely mixed, depending on which state and which particular procedural protections are embedded in that state's statute. And as of this moment, the Supreme Court itself has never issued a direct ruling on whether red flag statutes as a category are constitutional. That gap, intentionally left open in 2021, remains open today. In the years since Caniglia, a separate landmark ruling in 2022, New York State Rifle and Pistol Association versus Bruin, transformed how courts evaluate virtually every firearms regulation in the country by requiring laws to align with the nation's historical tradition of firearm regulation rather than merely weighing public safety against individual rights the way courts had done for decades prior. That new framework has been applied by lower courts specifically to red flag statutes in subsequent years, with some tribunals upholding ERPO laws under the historical tradition test by pointing to old surety laws and going armed statutes from the founding era as sufficiently analogous historical parallels, and other courts expressing doubt that those old narrow statutes truly provide a close enough match to justify the modern, far broader practice of temporarily removing firearms from someone's residence. That disagreement among courts applying the identical legal test to the same category of law and arriving at different conclusions is precisely the type of split that eventually tends to compel the Supreme Court's intervention. But as of right now, it has not yet reached that point nationally. The fifth portion is the pattern worth grasping regarding how the Supreme Court has handled petitions to re-enter this area since Canelia. Cases asking the court to clarify how far Fourth Amendment protection extends into weapon seizure situations, and separate cases asking the court to weigh in more broadly on Second Amendment ownership restrictions, keep reaching the justices through the certiorari process, and the court keeps declining to accept most of them. As recently as January 2026, the Supreme Court rejected multiple petitions in a single conference asking the justices to revisit firearms rights questions, including challenges brought in cases such as Zurich versus Bondi, Duarte versus United States, Collins versus Bondi, and Pierre versus United States, each testing a different edge of federal firearms restrictions, most centered on whether individuals with prior felony convictions can be permanently prohibited from possessing a firearm at all. That is not an isolated denial. It reflects a consistent posture the court has maintained for years now, allowing the narrow, specific holding of Canelia to stand exactly as written while declining case after case to expand or clarify it further, leaving the harder, broader questions to simmer in the lower courts instead. When the Supreme Court denies a petition for review in this fashion, it comes with no explanation. There is no opinion, no vote tally released, no reasoning attached, just a single line on an order list noting the petition was denied. The lower court ruling beneath simply stands, and everyone is left to speculate why the justices passed. Some legal observers interpret this pattern as the court exercising caution, waiting for a genuine circuit split, meaning different federal appeals courts reaching opposite conclusions on the same legal question before stepping in. Others interpret it as a quiet signal that the current court is comfortable, leaving red flag laws and related weapon seizure questions to individual states for now. It's worth noting that the justices do occasionally note a dissent from a cert denial, meaning one or more justices publicly object to the court's refusal to hear a case, which gives outside observers a rare glimpse into internal disagreement. When that doesn't occur, as has largely been the case with the weapon seizure and red flag question specifically, it typically means there wasn't sufficient internal appetite among the justices to take the case up at all. Not necessarily that the underlying legal question is considered resolved or insignificant. The sick is what the two sides of this debate actually argue, and both deserve fair presentation, because this is one of the rare firearms questions where the disagreement is genuinely about procedure and protections, rather than a flat yes or no on the underlying policy. Gun rights advocates focus heavily on due process. Their core concern is that many red flag orders can be issued on an emergency temporary basis before the gun owner is ever notified or afforded a chance to respond, meaning someone can lose access to their weapons based on one side of a dispute being presented to a judge, with the full hearing and opportunity to contest it occurring only afterward. They argue this ex parte process, meaning without the other party present, creates genuine risk of weapons being seized based on incomplete, mistaken, or even malicious information before the affected individual ever gets to speak. Gun safety advocates focus on the public safety side of the same coin, citing research suggesting that removing firearm access during an acute crisis, even temporarily, can materially reduce the risk of both suicide and violence against others, and noting that most existing red flag statutes already require a judge's approval, rather than permitting police to act entirely on their own judgment, which was precisely the defect the Supreme Court identified and struck down in Canelia itself. It's worth noting where both sides actually agree, because it gets drowned out in online shouting. Neither side is arguing that officers should be able to walk into a residence and take weapons purely on their own initiative with zero judicial oversight. The real disagreement is about timing, evidence standards, and how quickly a full hearing must occur after an emergency order takes effect, not about whether courts should ever be involved at all. Gun rights organizations have generally advocated for reforms requiring the individual facing an order to be notified and given an opportunity to respond before weapons are removed whenever feasible. It's the specific words in the opinion, the questions the justices explicitly decline to answer, and the years of quiet, unglamorous litigation that follow, as everyone else tries to figure out exactly how far it reaches. You deserve to understand where the actual line sits, not merely the version of the story that fits neatly into 30 seconds of outrage or celebration. Whether you own firearms yourself, have a family member who does, or simply want to understand how the Fourth and Second Amendments actually intersect in the moments that matter most, knowing the real boundaries of this ruling and the real gaps still sitting inside it puts you ahead of almost everyone still repeating the flattened version of this story from 4 years ago. If this helped you understand what Canelia truly does and does not protect, share it with a gun owner in your life who's never actually read past the headline. Subscribe so you catch the next ruling the moment it drops.